And so we'll continue on and address the revised petition momentarily. First thing is a recording of the record. Everyone is here, so I appreciate all Charter Commission members being here. The next thing we'll address is the public comment period. Mr. Secretary, did anyone sign up to?
Yes, sir. We have 4 people that have signed up.
Okay. What we'll do is, not only in accordance with state law, but also what we would do otherwise, is allow anyone who wishes to speak an opportunity to address the commission. I will say the same thing I said at the last meeting, which is we are not passing on whether this charter amendment is a good charter amendment or a bad charter amendment at this point. Our role is to determine under the revised charter procedures whether it meets the requirements, so that then the proponents can go out and seek to obtain the number of signatures that they would need to put it on the ballot. So if that changes anyone's desire to appear, you're certainly welcome to make whatever comments you want to. Would ask that people try to limit it to a couple of minutes, just to give everyone a chance to speak. So with that, we will open the public comment period. And if you would, please state your name so we'll have it in the record.
First is Mr. Shane Smiley.
Good afternoon. My name is Shane Smiley. I live on Brush Hill Road in Nashville. I appreciate y'all being here. And in the last meeting, as the esteemed commission spoke about, this is the first time we've gone through this process, and that we need to get it right. And I applaud that. This is very important. In the application process, there is a statement of financial impact. And that statement of financial impact is put in there as a part of Charter 1902. But yet, through the process at this point, we've seen nothing from Metro Finance to the levity of what is being put forward. There's no financial review from Metro Finance. I've been told that it doesn't matter with this, that it matters if this were coming through the council to you, that you would have to review it, but if it's coming from the citizens, that doesn't weigh. Well, my question would then be, why is it a required part of the petition? And as it is a required part of the petition at this time, then it should require that look over financially. If you, Kenny Bird's acting as an agent of Fairgrounds Preservation Partners in putting this petition forward. Their first act was to put forward through social media and media in general, a proposal to destroy 120-year use of the fairgrounds through the Speedway. That's where they want to put this additional affordable housing and parkland. Well, that's going to destroy 1,105 parking spots. You can see on the submittal that I put forward to you that what they intend to do, but you can also see where Metro government and Kimberly Horn, in the lawsuit over the soccer stadium and mixed-use development, put forward that the Speedway property would be protected and testified to the court that it's a vital part of keeping the charter-protected events alive. So we have over 200 expo events a year at the fairgrounds. We have 12 flea markets. These are all multi-day events. They're non-soccer events. The fairgrounds gets 50% net proceeds from that parking off of those 1,105 spots and more. The Speedway lease, which could be, with what's coming up, could be over $1 million a year. But as it stands right now, the area that they're talking about doing is more than 1,105 spots and equates to hundreds of thousands of dollars worth of revenue to the fairgrounds, which is the Fairgrounds Nashville, which is an enterprise fund. They're supposed to be living off of what they bring in. So if you take that area away from them, it's just going to mean that they have to go to more and more subsidy to the taxpayers of Davidson County in order to continue to operate the charter protected events of the flea market, the expo event, center, and what would be left would be the fair as well. So this has dire consequences, potential dire consequences to the finances of the fairgrounds and therefore to the taxpayers of Davidson County. So I'm really curious to hear what y'all have to say about why this is a part of the petition and not being addressed. And I hope it is something that, before we move forward, will be addressed, and we'll hear something from Metro Finance's, their opinion of what harm this could or could not do. Because as it stands right now, saying that having to put it there and there'd be nothing, and to say that it has no financial consequence, that's a fairy tale. We all know it's a fairy tale. So I could put one out to say that it's, do a petition and file it out, and I could put in there that the Tooth Fairy is going to give everybody $1 million, and it's the same fairy tale of harm that would be done. So I hope it's something that we'll look at, and I do appreciate your time. Thank you so much.
Thank you, Mr. Smiley.
Next, we have Mr. Steve Ryder.
Thank you, Mr. Chair and members of the commission. It's like, here we go again. What is put forward, the revised version of the petition, makes reference to the Tennessee State Fair and the Tennessee State Fairgrounds. That is more than just an oversight or a clerical error. The Tennessee State Fair is now in an adjacent county, Wilson County. It's been there for a while now. And the Tennessee State Fairgrounds, it was rebranded in 2015 as the Fairgrounds Nashville. So what is being put forward for your consideration today is really not something that the citizens of Davidson County can really weigh in on, because the Tennessee State Fair is no longer here. The state took that away. They have the rights to the name Tennessee State Fair. So I guess I could leave it at that. I heard Mr. Smiley talk about the fiscal note or that. I have no idea how you can go out there and do any sort of analysis when they don't go out there and provide you information. I think I'm not sure, but I do believe the fairgrounds right now operates as a deficit on a regular basis. And my understanding, going to the Arts Commission, if they're operating at a deficit, that they basically have, they can no longer expend funds. So there isn't anybody that I'm aware of from the board of the fair commissioners, or if somebody could weigh in on that. I don't know if that's your job. I don't know what your scope of work is, frankly. So it's a little bit confusing to me. I'm still learning the process, but I look forward to the rest of the meeting. Thanks.
Thank you. Thank you, Mr. Ryder.
Next, we have Mr. Daniel Barron.
Hello, Commission. As I was listening to Mr. Ryder speak about the use of the name Tennessee State Fair and Fairgrounds, that has been under statute, under TCA 457-106, and it's been in place since 2012. To move on to my comments, I'm working off of the last page of this meeting's materials, filed with the clerk on March 4th of this year. And I'm also referencing Exhibit A from the prior meeting, which is not in this packet of materials, but I don't know if you have it with you. Exhibit A, the petitioners provided with their letter from January 31st, and it contains deletions under 11602D that are not represented in the filed petition from March 4th. This is deficiency. Particularly the fact that they're wanting to remove the Fair Board's legal duty. They have not made known in the petition that they are removing the phrase "shall be continued on the same site." I think we all know that the word "shall" has legal weight and imposes a legal duty on the Fair Board. So while in one hand they're offering the public this idea that they're just simply removing the phrase auto racing and replacing it with affordable housing, but on the other hand they're surreptitiously removing the legal duty for the Fair Board to continue the remaining activities that have been charter protected: the flea market, the expo events, and the divisional fair. And the moment that if this charter amendment passes, the Fair Board will no longer have that legal duty to continue those remaining activities at the fairgrounds. And they are subject to being shoved off to wherever they may land. The other deficiency I've noticed is that they include in their, I'm looking at the March 4th filing, In item number 2, they include the term outdated in the phrase outdated reference to December 31st, 2010. I think outdated is their opinion. I don't think that's permissible. They can't include, as I followed as a lot of the public did, the 2010-2021 Chancery Court hearings on the National Taxpayer Protection Act, I think we all learned then that we cannot have a petition that contains marketing language or the petitioner's opinion in it. I think outdated qualifies as that. Additionally, there is, in the charter of this government, there is no 11.602 point parentheses lowercase d. There's a typo in that as far as I'm concerned. So just to recap, as far as the deficiencies are concerned, on the March 4th filing, the title in item 1 is insufficient. It doesn't fairly convey what this amendment is about. In item number 2, the explanatory summary, they had at least 200 words to work with, and they leave out the critical duty that is in the phrase shall be continued on the same site. In number 3, I think quite fairly to have the petitioners approve the Tennessee State Fairgrounds and Tennessee State Fair as phrases, it doesn't jive with state law under 457-106. And then I think Mr. Smiley adequately addressed the item number 4 on the financial impact. It's simply not fair to say this would have no financial impact. It would have quite a financial impact. So thank you for your time.
Thank you, Mr. Barron. Is it B-A-R-O-N or T?
Correct, yes. It's Red Baron. Yep.
Last, we have Mr. Carter Swayze.
Hi, I'm Carter Swayze. I live on Princeton Avenue over off West End. I'm an affordable housing developer by trade, and I can tell you that it is my job to produce affordable housing from a ground-up perspective. And the opportunities for us to do that are getting smaller and smaller each year. It's because the federal government incentivizes a large portion of affordable housing production through the low-income housing tax credit. That is given priority based off of specific census tracts in Davidson County and nationally as well. Those census tracts are divided into 2. There's a qualified census tract where there's poverty concentrated, and there is a DDA, which is called a difficult development area. That is where high-income households are populated. This is, the fairgrounds is supposed to be in a DDA next year. And the ability to develop affordable housing has mostly been shifted in the North Nashville quadrant over the past 10 years. And I wanted to reach out to you guys to say specifically, I ask that you support this amendment. It is critical. There's no land where we can develop low-income housing tax credits from a large community perspective. This pairing with the soccer and creating a new park would benefit the city overall, and there are financial implications to this, but what the worldwide or the county-wide implications are far much greater. Additionally, a lot of these communities can pay property taxes, and they may not be as large as what they're generating for parking right now, but it will still make up a significant delta, which is important to the city, and just wanted to let y'all know that. Thank you.
Thank you. Okay, anyone else that didn't get their name on the list that wishes to? Yes, ma'am.
Hello, my name is Heidi Baskell. I live at 1711 Neal Terrace, 37203. I'm a 22-year resident of Wedgwood, Houston, right down the street from the fairgrounds. My good friend Kenny Bird, who is the co-signer of this petition, could not be there, so I'm representing him and myself today as a co-signer. And we really appreciate you all reviewing and considering this. At the last meeting, I'm sorry I wasn't able to be there, but I understand that it was a template issue. So we've resubmitted our language in the template that you gave us. And I humbly request that you vote to certify and let me know if you have any questions. Thank you.
Thank you, Ms. Baskell. We appreciate it. Okay, anyone else? Then at this time, we'll close the public hearing, and we will move on with our agenda to the approval of the minutes of the February 22nd board meeting. They were circulated. I hope everyone has had a chance to review those minutes. Is there any discussion? And if not, we'd entertain a motion on those minutes.
So moved. Second.
Okay, have a motion by Ms. Jones, second by Ms. Behan to approve the minutes of the February 22nd meeting. All those in favor, please say aye. Aye. Any opposed? Then the minutes will be approved unanimously. So next on the agenda is notice of appeal rights. That I guess, yes, Austin, you will take care of that for us?
Yes, sir. Parties wishing to appeal a decision of this commission are encouraged to engage independent legal counsel to determine the appeal rights and deadlines. Generally, appeals of metropolitan boards and commissions are initiated by filing a writ of certiorari with the Davidson County Chancery Court. A decision by this commission to certify or not certify a petition may be appealed to the Davidson County Chancery Court by filing a writ of certiorari within 30 days after the decision of this commission.
Okay, thank you for that. Next, we'll move into the consideration of procedures for petition-initiated charter amendments. The Metro Legal Department has prepared some guidelines for us that I think we need to discuss. Ms. Ecke, if you would like to just summarize for us what you've done and what you would recommend that the commission do related to these procedures.
This was prepared in response to a request made by the commission at the last meeting. This essentially lays out the steps for charter-initiated petition amendments and reflects some duties that this commission is required to perform, for which are ministerial, and for which the commission can delegate either to its chair or another designee. It lays it out in chronological order. That's why it's a little wordy, so that you can kind of see the chronology of events. I don't know whether you have any specific questions. Do you want me to go?
Yeah, if you would just go through, kind of briefly summarize how you see it working from the point where we approve the petition, which would be today's step, or don't approve the petition. Obviously, if we don't approve the petition, then we know the next step would be someone would have to file an appeal. So we don't really need to talk about that one. But assuming we approved it, tell us what this provides for process after that.
Okay. So if you approve the petition, basically a decision to certify may be appealed to the Chancery Court by an affected party via writ of cert within 30 days after the decision of the commission. So the Department of Law will notify the commission regarding whether a timely appeal has been filed after the end of that 30 days.
Nikki, let me ask a question. I'm piggybacking on what Jim said. Who has the right, who would be an affected or an aggrieved party? I know that's a tough question.
Yeah,
I'm just kind of throwing that on you, but in thinking it through, let's say we approve this and one of the folks that came and doesn't like the petition and says, well, I want to appeal that. Who has the right to do that?
Okay, what I can say is that the individual that filed the petition can appeal your decision.
If we were to deny it.
Exactly. With regards to whether anyone else has the right to appeal or whether they have the standing, I think I just don't want to prejudge a court on that issue. That's something a court will have to determine whether whomever it is, that other person that filed the petition for writ of certiorari has standing to bring such a lawsuit.
And basically, they'd have to convince the court that they meet the traditional criteria for standing.
Correct.
Where they had a particularized injury versus an injury that everyone in the public shares, right?
Correct.
So assuming we don't have an appeal, assuming it goes forward, then what happens after
The 30 days, yeah. So after 30 days, then Metro Legal will inform this commission as to whether or not an appeal was filed. So if no appeal was filed, this commission is required to notify the individual that filed the petition that no timely appeal has been filed. And the commission is also required to file the petition that you certified with the Metro clerk. So we are suggesting that the chair or a designee of the chair will file, once you receive notice from Metro Legal that no appeal has been filed, that the chair within 2 business days, to the extent practicable, file the certified petition with the clerk. And the reason we add that qualifier is in case there's something that happened, there's a flood or something, hopefully not, but that there's reasonable time to engage in that task. And then once the chair or his designee files the certified petition with the clerk would immediately notify the petitioners that the commission has filed the certified petition and that no timely appeal was filed. And then thereafter, the individuals that filed the petition can circulate the certified petition for signatures. And then the charter requires that the completed petitions be filed with the Metro clerk within 90 days after the commission files the petition with the clerk. So the key date is the date that the commission files it with the clerk, and then the petitioners have 90 days to return the completed petition and file it with the Metro clerk. Once the clerk receives the completed petitions, the clerk would immediately deliver those petitions to the Election Commission. And then the charter requires that the Election Commission the charter essentially gives the Election Commission 30 days after receiving the completed petitions to certify the number of registered voters who signed the petition.
So basically, their job then would be to take the petition and compare the signatures to the voters' records to make sure that there are enough signatures on the petition.
Correct. They will actually,
Match.
yeah, they will provide a letter reflecting the number of signatures that of eligible voters, number of eligible voters who signed the petition. And we recommend that while that process is going on, before it's completed, just in case at the end all requisite numbers are met, that the commission meet to approve a form of the ballot, the actual language of what will go on the ballot. Usually what goes on the ballot is the summary and the full language. And so the clerk will set a meeting, and while the verification is going on, for this commission to meet and approve the form and content of the ballot. And
Would the Election Commission prepare the actual form of the ballot? Is that?
Well, the commission is required to basically, generally, the Election Commission does also prepare the ballot, but they need to prepare it in conformity with what you approved. So
we would get something from them that we would then need to, as I understand it, they would prepare something and it would come back to us and we would say, this does meet what we approved or it doesn't meet what we approved. Is that the process?
no, initially you will actually adopt a form of the ballot, the language and the content of the ballot. And then they are required to, the Election Commission is required to prepare the sample ballot, and they are required to provide that to you at least 7 days before it's finalized for your review. So at that point, what will be done is to see whether what they've prepared, their own ballot, is consistent with the form and content of the ballot that you prepared and provided to the commission. And so we recommend that the chair review the ballot that's filed by the Election Commission and compare it to the ballot that you approved. So you get to meet before the commission even gets to the ballot stage, while they are doing the certifications. They're going through the verification of signatures to approve a form of the ballot. Basically the summary and the language that goes on the ballot, and then.
And is that prepared by the legal department?
Yes, we prepare that, provide that to you. You look at it at an open meeting and vote on it.
It should be pretty simple, so
Yeah.
we should be comparing what's on the ballot with what's in this petition that we've approved, and if it's the same, then
Well, the ballot may not be exactly verbatim
If it
because it's going to be written in a manner that, appropriate legal manner,
Right.
that,
Yeah, but I think what we're looking at is, does it match this from the standpoint of, is it conveying the same?
exactly. It may not be the same verbatim
Right.
A, B, C, D in terms of, comma here, language here.
Can you correct, one of the speakers made a point that it looked like there was an extra point before the B in parentheses. Is that something that the legal department could correct if there's like I guess maybe a typo, or if there's something in the wording that doesn't change the import but makes it conform with the actual language in the charter? Is that something that can be done?
Well, we can. That's not saying that what they have said accurately portrays what actually has occurred. They are asking to delete one sentence and replace it with the other. So the language of the charter, the full language will say something to the effect that the first sentence of section this of the charter is deleted and replaced with the following sentence. Then there's a summary. The summary, you can play with it, but, so long as it reflects the nature of the change.
And there's leeway for the legal department to make sure that fits the form of the ballot. Obviously not the actual amendment itself, but the 200-word summary is something that.
Sure.
I guess what I'm asking is, we don't have to, or you're not bound by
The summary.
the summary on
No,
this.
we are not bound by that summary, and in fact, under state law, the county attorney does write the summary.
Okay.
So we are not bound by the particular summary, language of the summary, exact language that's in the petition.
Do you have any response, or can you give us some idea about their concerns about financial impact being included? Does it really need to have more information?
What I can say on that issue is that what has been submitted, the charter requires that the proposed petition contain a statement of the financial impact of the proposed amendment. What has been submitted meets that requirement. I think people can reasonably disagree as to what financial impact may be with regards to a particular charter amendment, but what has been submitted meets that requirement. And that information doesn't actually go on the ballot. That's just on the petition. And there's no requirement that the Metro Finance in any way opine on that issue under the charter.
not to get too, not to get afield, but for this particular petition, since it's not mandating the expenditure of funds, I don't perceive from my limited view that it's requiring, it's not like saying you've got to hire 200 more police officers or add 50 more ambulances. But if there were a petition filed that would clearly require Metro to expend funds, any thoughts, and I know I'm catching you cold, but any thoughts on how that would be vetted to determine the financial impact? Who would actually make that determination? And if there were a question about whether what the petition said was or wasn't accurate, what would be the way to correct that or figure it out? Is there, and I know Nikki, I know I'm catching you cold on this, but it's just something I was thinking about as far as the financial impact.
The way the charter is written, it's not, I don't think it's really a function of this commission to make judgments as to whether or not this will be the particular financial impact of a particular charter amendment or not. I think this is more to provide information to those wishing to sign or not sign the petition. And those that disagree can, definitely send a contrary message via any media they wish. But I don't think it's, so long as it doesn't say something completely unreasonable, like, the moon is red or something, that has nothing to do with financial impact. I don't think that you get to vet as to, get into a detailed financial analysis as to what the particular impact will be.
So it would more fall into the political realm for people to argue whether the petition should be approved, either signed, and then if it were to be enough signatures obtained, then it would be up to people who are proponents or opponents of the amendment to then go out and make those arguments. Is that?
Yeah, I think so. I think it's just to provide information to voters. Potential, not voters, this is potential petition signers. When this is on the ballot, people can make their own independent judgment as to whether or not to approve this amendment. Like I indicated, the actual financial impact, that does not go on the ballot. What goes on the ballot is the summary and the full language of the amendment.
Okay. If we approve the procedures, which there are really just a couple of things the commission needs to do. One is what we're doing today, which is pass on the validity. Does it meet those 4 requirements of the charter? Then we wait 30 days to see if anyone files an appeal or a petition for certiorari. And then if they don't, then the clerk will certify back to. Yeah, I'm trying to just make sure I understand what it is that the commission needs to do as opposed to what we can. If it's a purely like notifying someone, then it would make sense for us to delegate that task, maybe to the clerk or to someone in the Metro Legal Department. I don't see a reason for us to all get back together if it's just a matter of saying yes, no appeal was filed.
I think that says the chair can do that.
Yeah,
The chair can tell.
a designee of the chair.
Can tell the clerk that the petition, that nothing's been filed. So I don't think we have to meet. The only thing I saw where we would have to meet again would be to actually review the ballot and make sure the ballot matches the petition.
No, for you to actually adopt a form and content of the ballot. You
And
do
you would
that.
provide us with the copy.
Yes, a draft. So that.
But that's post-petition, everything's been signed, the election commission has prepared a ballot.
No, that is
They're
before.
reviewing the signature.
They're still reviewing the signature.
Okay.
So you get up front and you meet and you approve a form and content of the ballot.
Okay.
And then if what you approved is not what they file with the clerk,
Okay.
then we can follow up with the election commission, the
Right.
chair or
Okay.
designee, yeah.
Prior to the election commission's completion, clerk will schedule a meeting of the commission to adopt the form and content of the ballot. Yep. Okay. And basically, that just is making sure that the ballot that they're gonna use, we think substantially conforms with what we've approved.
Correct. So once they get what you've approved, that will be provided to them. They're still required to file with the clerk the actual referendum ballot at least 7 days before it's finalized.
Yeah.
So once they file the actual referendum ballot, that will be compared with the document that you approved. That's essentially a ministerial duty that the chair or a designee of the chair can perform. Just look at the two and are they the same?
Okay.
If they are not, the election commission will be asked to revise it, and then we'll go from there.
So, but you would be drafting the language
Correct.
to go on, and then the commission would
And
actually
meet.
print like a sample form of.
Oh, well, it just has, it's just on a piece of paper that just has, amendment to the charter of the Metropolitan Government, summary, and then full language, and it has those texts, and that's provided to the commission, to the election commission.
And so they won't change that then?
Well, they'll put it in the proper format in terms of machines and all that, but
Wording.
they shouldn't change the wording.
Okay.
Yeah.
And then they give us what they prepared to review?
Yes, they're required to file the ballot with the clerk 7 days before it's finalized. So once they file that ballot, it will be compared with what you already sent them up front to see whether they are consistent. If they are consistent, no further action is needed. If they are not consistent, the chair or designee can ask them to please conform it to what was approved. And then we'll go from there.
Well, what I'm assuming is if it came back and it was non-conforming, you would look at it and say,
Sure.
here's an issue and then we would need to say, no, commission, you need to
Correct.
fix it. Is it just this part of the ballot, or does it have to be part of an overall
No,
ballot?
just that language.
Okay.
They filed a sample referendum ballot, so all they really need to file is the referendum section of the ballot that has the language of the charter amendment. Not like candidates or whatever else on the ballot.
We can't control candidates.
No.
Candidate placement.
Even if we wanted to.
Candidate placement or any of that, yeah, that's right.
Okay.
Mr. Chair, I'll move we approve the procedures as provided by Metropolitan.
Okay, we have a motion to approve the procedures. Do we have a second?
Second.
Second by Mr. Laughlin. Any discussion on the procedures as provided to us by Metro Legal? And I want to say before we vote, thank you, Nikki, for putting this together. It's very helpful to, as we're going through this process for the first time, to have an outline of what exactly it is that we need to do. And assuming that this, I'm not jumping forward, but assuming we were to approve the petition before us, then you would communicate back, I guess, with me at an appropriate time that, hey, 30 days has passed and no one has filed an appeal.
Yes, we'll communicate that to the whole commission, so the whole commission is aware.
Okay.
After that 30 days has lapsed, whether or not an appeal was filed.
Okay. And then it goes.
And then from there on, we can work with the chair or the chair's designee to ensure that if there are no appeals, to ensure that the chair or his designee files the petition with the clerk, and also work with the clerk that the petitioners are notified of the filing by the commission of the certified petition, and that they are notified that they can then start collecting signatures.
And then they have 90 days from the date that it's filed with the clerk.
Yes.
And is that, again, not to get into the weeds, but to try to avoid a potential issue, if that 90 days falls on a Saturday, Sunday, or holiday, does it roll to the next day, or is it a?
Yeah, usually because it's within a particular number of days. If that last day falls on a holiday, it goes to the next business day.
Okay. I know sometimes in election law that it's a certain amount of time, and you don't get the benefit of if it falls on a Sunday, you're just out of luck, so. Okay, we didn't vote, I'm sorry. We have a motion and a second to approve the procedures that the legal department has so graciously prepared for us. If there's no more discussion, all those in favor, please say aye. Aye. Any opposed? Then the petition-initiated charter amendments procedures will stand adopted as presented. Okay, this takes us down really to the business why we're here for today is this the revised form of the petition that we reviewed at the February 22nd meeting. Ms. Ecke, you have seen this petition that's been presented to us. It appears that they used the format that we had adopted at the last meeting. From your position, is there anything about this petition that does not meet the four requirements of the charter as it was amended in 2022?
No.
And Mr. Chairman, if you could identify those four requirements again for the record?
Let me just pull it out right now, and I will tell you what they are so I don't misstate.
The last page.
It is that the title of the proposed amendment, an explanatory summary of the proposed amendment not to exceed 200 words, the text of the proposed amendment, and a statement of the financial impact of the proposed amendment. That's what the petition has to say.
Requirements.
And then we're supposed to review it to make sure that it's not unconstitutional, that it doesn't conflict or is facially inconsistent with state or federal law, that the subject of the proposed amendment is not, it is something that can be subject to a referendum, that it doesn't fail to convey a reasonable meaning, and it doesn't contain more than one subject, and that it is not something that is clearly not allowed under state law. Those were the other requirements, and based on our last meeting in the review of the legal department, and Nikki, if I misstate something, please tell me, that the proposed language did not run afoul of those criteria as is found in section 1903C. The only issue was whether it was in the proper format. So
That's correct.
So I think we've been advised and that it meets the requirements of C, and then the question was that the petition had to be in a particular format that it was determined at the last meeting was deficient, and so now it's been refiled. And again, you know, Ms. Ecke, if I'm misstating, let me know, but it's the opinion of the legal department that the form of the petition is now complies with the Metro Charter.
That is correct.
Okay, I think then our task at this point is to approve or disapprove the petition. And again, it's not our role to judge the validity or invalidity of the petition as far as what it seeks to do, only whether it meets those criteria. So, and it appears that based on opinion of counsel that it does meet those criteria.
Thank you.
So I guess we need a motion to either approve or disapprove.
Motion to approve.
Okay, got a motion by Mr. Harden, seconded by Ms. Jones.
Yes.
To certify the.
To certify. Thank you. Yeah, to certify. Also, you'll make sure it says certify in the motion, Hal, I think that would be sure. To certify the petition, then is there any discussion on the motion?
I have just a comment. I mean, I do understand the concerns raised by the people who have submitted either letters or spoke here today, and No, it's not clear under this language what our role is in addressing the validity of the statement of financial impact. I would say we are uniquely unsuited to do that.
We're lawyers, the only thing we know how to divide by three.
I'm mathematically impaired, but so again, I think you might have made the comment, Mr. Chair, that this is more of a political issue for the signers of the petition than it is a legal issue that we have to approve or back the validity of the financial statement. Because I don't know. I don't know whether the financial impact will be as stated in here or as stated in the letters and comments, and I'm not sure anybody really knows, and I'm not sure it would be possible to really articulate and determine a financial impact. It makes you wonder kind of what is that there for? And I guess in thinking about it, your answer might be the best answer. It's there to put the statement out into the public that that's what the petitioners are contending. And then if people who disagree with that see it and say that's wrong, then they cannot sign the petition. And so to me, that's the only way this makes much sense, because otherwise, you're putting this group in the position of making decisions that are, one, not within our area of expertise, but more importantly, probably at best a subject of debate between various folks that is not really capable of being resolved in this form. And so I think they made a good question. I think one of you said, this is the first time we've ever done this, and this is the first time we've ever done this. We're struggling with it too. But I have to think that your characterization of what that requirement is for is correct, and that's really to put it out there what the proponents say, and they can stand or fall on whether the public believes what they've said. And I think that would be the other, the best way to go. The other comment one of the presenters made was about the language removing the duty to conduct these activities. I don't think that's right. He's correct that the language in this sentence doesn't say that it's a duty, but if you go back and look at 11-602, 11-602 says the following says it shall be the duty of the Board of Fair Commissioners to D, conduct activities on the premises of the Tennessee State Fairgrounds, including but not limited to. So I don't think that's a substantive language change from the standpoint of eliminating duties. It's just maybe clearing the language up. I think what happened was 11-602 A, B, and C were in the charter prior to the amendment adding D. And so, as is the case, or particularly was the case before you had the Charter Revision Commission having the duty to look at all of this before it gets on the ballot, things got put in to the charter in a way that maybe was repetitious of, stating what the duty is. So I don't think that's a significant deviation. So for that reason, I'm supportive of this as being compliant with the requirements under the charter.
Okay, any further discussion on the motion to certify the petition? If not, then all those in favor, please say aye. Aye. Any opposed? Then the motion to certify the petition is approved unanimously. So As far on the agenda, our next item is next steps in scheduling. So starting today, someone has, and it's from today. It's
Today,
not
correct,
from-
30 days from today.
From today, this is considered to be official action. So
Correct.
then, after 30 days,
How's time?
come in. So then, once that's up, you'll let the commission
commission
know,
know
and
when-
then it'll go back to the clerk.
And then, yeah, so that the chair or designee, if there's no appeal, can then file that petition
Do
with the
we
clerk.
need to get a stamp or something that we can stamp on the petition that says certified, so Dewey can send the certified copy to the clerk?
How does that work?
Sure, I can
I noticed
do
you
that. I mean,
Or your designee, but you're gonna have the stamp.
I'm designating Jim Murphy.
Please don't, please don't.
sure.
Metro Seal, isn't it?
Because it will just remove this, this is what was filed, it has a date it was filed, but that date won't be there. It'll just, it can
Yeah,
have
so we
something
can
that
just
says
reference-
certified.
we can Just reference that stamp of the clerk of that date as being the certified petition. Yeah, that makes sense.
So,
You don't have to buy a rubber stamp.
Stamp, so.
And the minutes will reflect.
And the minutes will reflect as well, but yes, but as Ms. Eckert points out, the petition has a date, March 4, 2024 at 3:10 PM. That's the one we've approved.
for it to be filed, yeah.
Okay, then one last question I have is I received a letter today from someone who is the chairman of the Nashville Board of Fair Commissioners, Nashville Fair Board of Commissioners, Jasper Hendricks, that appeared to have been copied to the clerk's office. Will that be something that will be made part of the record, or what? Anyway,
I would move that we do include that as part of the record, just for the purpose
Thank you.
of, if there's an appeal, it's clear that that letter was included. I definitely looked at it and
Yes.
considered it as part of the, my discussion, and I know you did too, because you were asking the same kind of questions that I had.
Raised some interesting thoughts. I don't know if anyone, I've got copies if
Yeah,
anyone
I didn't see
did not receive it. I made enough for everybody. Not everybody in the audience, but
Thank you.
commission members. So then, we have a motion by Mr. Murphy to include as part of,
So is this like basically public comment?
Yes.
So it's treated the same way as any other public
It's
comment?
same as the public comments, but just in case there's ever an appeal and someone says, well, what was the record on appeal? I want it to be clear that this letter was part of what we considered
Okay.
in making our decision. So that's my motion, is we include it in part of the official record so that there's no question that someone can come in and say, oh, you didn't consider my letter, or you didn't consider my letter, or whatever. So that's.
I second.
okay, we have a motion then to include the March 8th, 2024 letter from Jasper Hendricks as part of our formal record in this meeting.
As a comment? Public
Comment.
comment.
Comments.
Also, I think we ought to include the sheet that we got here today. This, that's the Axios heading that shows the two drawings. I think that ought to be included too. I'm glad somebody brought that up. Yeah, we ought to include that too, because I looked at that too.
Yeah, the other comments were oral comments.
Yeah,
This is just a written comment.
right.
So we will include that in the Axios Nashville as part of the
Record.
comment period. So-
Yeah, exactly.
Should it be read into the record then?
No, it doesn't need to. As long as we got a
The
copy.
public would like to hear it.
We're not gonna read it.
I will be happy to
Sorry.
provide you with a copy of the letter, and
Yeah.
I actually have an extra, so
Thank you, kind sir.
if you want to circulate it, you're certainly welcome to. So, because it is now, since it came to us, it's now a matter of public record. So it's public
Thank you,
record.
sir.
Okay, we have a motion and second to include the March 8th letter and the Axios Nashville handout that we were presented as part of the comment section. All those in favor of the motion, please say aye. Aye. Any opposed? Then those items will be included on unanimous consent. Okay, so we don't need to schedule another meeting at this point, I don't think. We will wait, Executive, to hear back from you.
Correct.
And what happens in the next 30 days, and then we will follow the procedures that you were kind enough to prepare for us, and now we know what we need to do. So if there's nothing,
Move to adjourn.
we have a motion to adjourn. All those in favor, please say aye. Any opposed can stick around. We stand adjourned.